Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about the case of Proven Industries versus Trevor McNally, because Proven Industries is doing something that initially I thought was just stupid, but now I think they might be up to something shady. I could be wrong, but that's what it looks like to me, and I'm going to explain why. Now, if you're sitting here wondering, what are you talking about? Well, Proven Industries is a lock-making company. They make this thing. And they did a video where they were showing how tough this thing is. They were saying you can't get into it with a sledgehammer, crowbar, etc. And in the comments on Instagram, somebody said, I would like to see Trevor McNally take a try at this. And paraphrasing here, they basically said, he would never try to go after our locks because he just goes after the easy ones. Now, if you don't know who Trevor McNally is, he is a famous YouTuber and so forth, and his whole thing is getting into locks. So when they call him out and basically say he's not going to come after this one because sort of implying that he sucks at what he does, well, what does he do? He gets into it with a piece of pop can. And so then they are in damage control mode because that looks really bad for them because these things are super expensive. I paid a little over $200, I think, to get this into Canada. I think it's like 130 US. So it's an expensive lock. It's not El Cheapo. So anyway, they basically accuse him of faking it in various ways. So he does a series of follow-up videos and showing that, yes, he can get into them. So Proven Industries sued him for defamation and trade libel and various other things because they want him to stop making videos because those videos are really embarrassing and are really hurting their sales. Okay, now I've already commented on the lawsuit, on the claim itself, and my comments were basically that I thought it was pretty dumb. But now they're doing something else that is potentially even dumber. So let's have a look at this. And yeah, I'm going to have some thoughts. And also, this might drag me into this case in that I might have to file something in response to this. And this is bizarre. So, here we go. Plaintiff's motion to seal under Local Rule 1.11. Now, this is a rule of court that allows them to seal documents so that they're not available to the public. But what it doesn't do is, remove those documents when they're already available to the public. And this is kind of relevant because if we look here, we can see this is on Court Listener. Court Listener is by the Free Law Project. And I'm just going to show you here their interface. And it shows, you can see the complaint and you can download the PDFs for any of that. You can see the summons. You can see the emergency motion for preliminary injunction. We're going to talk about that one. And all the exhibits are just there for download. And we can also see, declaration of Trevor McNally, all of those exhibits. I can tell you that anyone who's covering this case, like myself, has already downloaded all of those things because of course we did. And in fact, had already downloaded them before the motion came out because we're covering the case, right? We're downloading these things as they come out and having a read. So anyway, they now want them to be sealed. And this, to me, is kind of a problem. Let's talk about it. So, description of items to be sealed. They want to seal their emergency motion for a preliminary injunction and supporting documents. I already covered the motion for a preliminary injunction, but I didn't do a video on all of the supporting documents. I did download them. I did read them, but I didn't actually, cover them in detail because there's a lot, and most of them are sort of uninteresting. We're going to cover at least one today. Order setting hearing and notice of hearing. The defendant's response in opposition to plaintiff's motion emergency motion for preliminary injunction. Oh, that's a headache of a non-sentence. And declaration of Trevor McNally in supporting documents. Plaintiff's reply. And the corresponding things. Plaintiff's exhibit list, defendant's exhibit list, and defendant's witness list. By the way, I actually show up in that defendant exhibit list. A reference to one of my videos because I noted that I was able to get into this thing using a pop can. Now, I didn't get into it in the nice, clean way that Mr. McNally did, I used a pop can, the lock broke, but it broke in a way that opened, which, problem, because $130. The minutes from the hearing regarding plaintiff's emergency motion, defendant's exhibit list, plaintiff's exhibit list. And here's something that is kind of shocking. The court's yet to be issued order denying plaintiff's emergency motion for preliminary injunction for copyright infringement and defamation by implication, and transcript of the hearing. Now, this, I think, is the real prize here, because it's certainly something I would like to report on, like what the court has to say about why they're denying the emergency motion. I have suspicions, but I really want to hear their fair use analysis, right? Their preliminary fair use analysis. And I suspect that Proven doesn't want me reporting on it or you guys to hear about it, because I suspect it's really embarrassing for them. Because if it was good for them, they probably would be okay with that coming out. This motion to seal and accompanying exhibits, and collectively the documents described in paragraphs 1 to 11, will be referred to as the hearing materials. Okay. Now, they're going to go through a few steps. Necessity of filing the items. We're going to skip over that because basically, yes, this is a court proceeding. They have to file things. They're saying we're not filing these for no reason. Cool. Moving on. That's part of the test, but it's a boring part of the test for our purposes, so we're just going to skip it. Necessity of sealing the items. We're going to go over this briefly. They say a demonstrated pattern of harassment and intimidation by defendant McNally's social media followers and viewers. Now, I am going to give you my usual reminder here. Don't harass anybody. Like, the best thing to do with Proven Industries is just not interact with them. If you want to buy their locks, great. You can buy a lock on, Amazon or whatever. But if you dislike them, don't go and hassle them or harass them or anything like that. It's not going to help. It's just, dick maneuver. The problem is that anytime you do something really stupid on the internet, you're going to get hate mail. I have certainly gotten hate mail. I have certainly gotten death threats. I don't appreciate them, but I also most of them I just find kind of funny. Especially the ones from like anti-gun people. Those ones are the funniest when they're like, I'm going to kill you and I don't have guns. And I'm like, cool, game on. I do. Anyway, yeah, I don't get the logic. But anyway, don't threaten people. It's just not helpful. But they note, they say that defendant McNally's social media followers have engaged in coordinated attacks against plaintiff's executives, employees, and their loved ones on various social media platforms. We're going to talk about this as well. They say that people researched and then publicly disclosed online without authorization, commonly known as doxing, the cell phone number of plaintiff's president, Ronald Lee. I'm not sure how they found it, and honestly, I mean, that happens, but it's not great. They say they've sent waves of harassing, threatening, and intimidating emails, direct messages, comments, and calls. This will again tend to happen when you are the unpopular party in a very, very public and very, in a case that's getting a lot of attention. But there are some detailed examples. There are some harassing and threatening messages sent to his phone, messages containing racial slurs and violent threats directed to his son and family members. Again, not cool, but you get crazy people online. It is a thing. And I'm going to have some criticism of Mr. Lee for this. I'm not trying to blame him entirely, but I'm blaming him a little bit because he did some stupid things. And we're going to talk about the stupid things and maybe how you shouldn't do those stupid things. So 2 physical letters mailed to Ronald Lee's residence and addressed to his girlfriend who resides with him, but is not listed on the title or deed to the property. Now, here's where they get into a better argument. They say a key witness who is prepared to testify declined to appear specifically due to fears of retaliation and harassment from defendant McNally's social media followers. Well, this is what subpoenas are for. Like, if you've got somebody who doesn't want to show up, you subpoena them and you make them show up, right? Because that's how witnesses work. I'm a criminal defense lawyer. I mean, most witnesses that might be helpful to me probably don't want to show up at court. I subpoena them and I make them come. Like, that's how that works. The potential witness specifically stated, is there a way to leave my name and my company's name out of this due to concerns of potential blowback from McNally or others like him. And they note, additionally, Anthony Bonfiglio, another non-party witness. Now, here's the thing. Why are they naming people at this point? They're saying we're getting so much harassment, but they're naming people. We're going to talk about that too. Who ultimately agreed to submit a declaration, expressed hesitation prior to signing. He specifically asked whether the declaration would be public and stated, also, is this going to be public? My concern is that there may be some backlash from the other side towards my company. Well, here's the thing. If you want something to not be public, you have to file it under seal before it hits the public docket, not afterwards, because I end up with everything that gets filed publicly if it's not filed under seal ahead of time. So in 2023, defendant McNally posted a viral video claiming to bypass a lock made by Easy Home using a piece of a milk jug, which is, again, what he does. Like, he bypasses locks, usually in funny ways. The video reused copyrighted content and triggered widespread negative reviews to Easy Home by defendant McNally's social media followers and viewers. People tend to dislike locks that don't work well. When Easy Home issued a takedown notice, defendant McNally responded with another video accusing the company of censorship. This is, again, companies. You have got to understand the modern world. You have got to understand that the way to deal with criticism of your products is not by filing takedown notices. People hate that. People find it to be a party foul, and it usually generates more antipathy. And if you have a lawyer who's helping you out with these things but doesn't understand these issues, then that lawyer might not be doing you a good service, right? And I don't know if that's the case with Easy Home. Easy Home might have been advised that this was a bad idea and might have proceeded anyway. I don't know. So even a year later, Easy Home continued to receive customer reviews on Amazon referencing the milk jug videos. This incident illustrates defendant McNally's pattern of conduct, targeting a product or company through social media, provoking viral backlash, and encouraging his followers to perpetuate the harm long after the initial post. The missing part here is the encouraging his followers, because it looks to me like Mr. McNally might just be identifying a weakness in a product and communicating that to the public, who has an interest in knowing if the locks they buy are actually secure. And then the public gets upset because they might have, bought one of these things, or they might want other people to know, hey, I have seen a video that shows that this product is bad. You should not buy this product, warning other people in the public that the product is bad, right? That's how things are going to work. Let's say I discover that a particular car catches into flames if you, play, Rick Astley's Never Gonna Give You Up near it. Well, this would be a design flaw with the car, right? And if I put out a video proving that those cars caught fire when you did that and maybe killed the occupants, you would expect people to be upset with the manufacturer of that vehicle, and you would expect people to have further opinions and comments about it, even if I don't encourage them, right? That's not encouraging, it's just communicating that information to the public. Okay, carrying on. The same dynamic is now playing out against plaintiff, reinforcing the need to prevent future escalation by sealing the hearing materials. So they're like, we're getting a ton of bad press and we really want it to stop. The pattern of intimidation and harassment by individuals influenced by defendant McNally's content demonstrates the real and substantial threat posed by the continued public disclosure of the hearing materials related to plaintiff's emergency motion for preliminary injunction. These materials contain additional sensitive information, including the names of witnesses, details of their involvement, descriptions of plaintiff's internal business operations, and statements made during the preliminary injunction hearing that could be taken out of context or mischaracterized by defendant McNally's social media followers and viewers to further incite harassment of proven employees, their family members, or loved ones. This information in the hearing materials could be weaponized by defendant McNally's social media followers or viewers to escalate the harassment already experienced by plaintiff's employees, and their loved ones, and third-party witnesses. Once again, don't do that. But here's the thing. These materials contain sensitive information, including the names of witnesses, details of their involvement, descriptions of internal business operations. Okay. Okay, let's talk about that because yeah, they note the girlfriend of Ronald Lee. Great, they didn't name her here. That's a good move, but we're gonna talk about that. And they say, moreover, in the declaration of Ronald James Lee, docket entry 10-12, plaintiff discloses sensitive and confidential business information, including but not limited to 1. Product marketing strategies and online advertising performance metrics, internal customer service procedures and disruption reports, and specific financial harm resulting from Amazon indexing and advertising losses. These materials reflect proprietary commercial strategies and trade knowledge not publicly disclosed, and are of the type that, if revealed, could cause commercial disadvantage to plaintiff and benefit competitors or malicious actors. So they say this is information not publicly disclosed. Well, let's look at that because I kind of disagree that it was not publicly disclosed. I actually think that was publicly disclosed. So we can look a little bit because we actually have a copy of the we actually have a copy of this because it was released to the public. It was not filed under seal. And so he notes that things that were not publicly disclosed include: after the part 1 video, I personally handled or reviewed documentation including the following: A product return explicitly citing the McNally video. B, a repeat customer that was hesitant to purchase after viewing the video. This customer had previously purchased from us multiple times and had never indicated any dissatisfaction with our products. Probably because he didn't know to try to break into them, or how. However, due to the increased volume and stress caused by harassment from McNally's followers, our customer service team was unable to provide the level of support we normally offer, which contributed to the poor customer service. And reports emails and messages from customer service about disruptive inquiries stemming from the video. They say, skipping over a little bit, I was involved in Proven's decision to disable comments on multiple social media posts due to hostile and misleading user comments. Because of the large number of negative comments on the video, we disabled the comments from public viewing. They noted, some other interesting details here. They will skip over to some of the sort of bits that they say are also secret. They say, as a result of the fraudulent negative comments, Proven's products, particularly on Amazon, that is not a sentence. Proven has a measurable decrease in revenue, has a measurable decrease in sales on Amazon, and has experienced permanent, also not the word you want permanent, damages to its ability to sell its product. Specifically, Proven's product is not indexing on Amazon as normal, and Proven cannot have featured offers on its product. As part 1 of the McNally videos was posted, I observed a noticeable decrease in revenue, an increase in advertising spend, and a decrease in conversion. From the period of April through May, Proven saw a loss of revenue combined from Google Ads and Meta Ads conversion value versus previous. Later, I observed a further noticeable decrease in revenue. Further on, they say Proven saw a loss of revenue from combined Google Ads and Meta Ads conversion value versus previous, i.e., how many people are following the ads to their store to buy stuff, right? If I show 1,000 ads for this lock, how many people go and buy one, right? Since the string of recent videos started on May 23rd, Proven has seen a large increase in negative comments on Meta Ad and Google Ad posts, with many of them mentioning McNally or opening their locks with cans. Based on my observations and leadership role, I believe that Proven is suffering irreparable harm. The McNally video spreads a false implication that undermines Proven's credibility in the marketplace and for Proven's employees. The damage to Proven's reputation, goodwill, and customer relationships cannot be adequately remedied by money. So basically, if you are an investor and you're thinking of investing in Proven, this may not sort of strike you as a great thing for the company. But here's the problem, or at least one of the problems, is that when we look at their initial filings, they actually sort of identify a lot of these issues. Their initial filings note, we knew that we were getting harassed because they said, all of this stuff was causing harassment and harm and so forth, and we're suing over that. And they also noted that they were actually suffering from various financial losses. This is in their filings. They say this is causing us financial damage. They say that this is causing us to have to spend more on advertising. All of the things that they put in that declaration can be inferred from their initial filing. Like, you can tell that they're like, hey, how can I know that Proven is suffering a financial loss? Well, they say that they're suffering a financial loss, and they're suing over that financial loss. So what additional information that is top secret is in there? I didn't see anything about like specific numbers or, maybe like a product design that's currently a trade secret. None of that is in there. Okay, so they want to seal all of that. And I want to talk additionally about the declaration, because the declaration that he wants to now seal, he made some choices in it. And I just want to note that these choices were a really, really bad idea. And so let's talk about that. Here we go. So they say the volume and tone of messages received by Proven's team have created a disruptive and hostile work environment, raising concerns about employee well-being and safety. This has impaired internal morale and affected day-to-day operations. Specifically, one of Proven's customer service representatives, Mr. Blank, complained about the hundreds of messages he received and read from McNally's followers in the past few days. Okay, so he names that employee. I don't know that there was a necessity to name that employee here. They could have just said one of Proven's customer service representatives. They could have applied to name him under a pseudonym before they filed this. They could have applied to redact this under a file name. I've redacted this, but the unredacted version is available online. It's anybody can get it. And this is the bigger problem. My partner, Blank, has also received harassing messages through Facebook Messenger. And you'll note that the son has received messages where they say some pretty horrible things. But when he's already like, I'm getting harassed, naming his partner was a whole choice. And like, why would you name your partner? You could just say my partner has also received harassing messages through Facebook Messenger. And I don't think anybody would have complained about him not identifying his partner. Right? I don't. I don't think anybody would have complained. There's another employee, Blank, who was specifically mentioned in social media comments. I mean, the other side would have wanted to get these names, in discovery and so forth, but I don't think they would have cared if you didn't publish them in a public document. That was their choice, and it was a very bad choice. And unfortunately, when they're saying like, hey, we want to put this toothpaste back in the tube, you can't. All of those documents are already out there. I'm not including that information in my filings, but I'm not the guy harassing Proven Industries. I'm not the person sending any of these messages or anything like that. That's somebody else. And that person already has access to all of the things. So what do I think is going on here? Well, I think the big thing here is this bit. The court's yet to be issued order denying plaintiff's emergency motion and the transcript of the hearing. It seems to me that what they want to seal is the ability to actually see the ruling that they got against them. Now, I'm media. I want to cover these things. And I think covering the order that they got against them is entirely reasonable and just. Now, the local rules that allow for this sealing order allow for any party or non-party to intervene and to say, I oppose this sealing order. Well, guess what? I am not a party to this lawsuit, but I do have an interest in this sealing order. So I guess I'm going to have to go in, and I guess I'm going to have to file something. And this is crazy. Like, what? Proven, just as a little, like, future tip. If you don't want something to be made public, you need to file it under seal ahead of time, especially when you know that this case is already receiving national and international attention. I really do have all of the sympathy and the empathy for the people who are being harassed. They should not be being harassed. But at the same time, that's not a good reason to conceal the order that is being issued against you on this one. So, you know, you can't conceal your adverse ruling based on that. And some of the arguments, like, and if you need to conceal financial information, that's a good reason to seal something, but you got to do it before you file it publicly. Because when you tell the court it has never been released publicly, you did that. You did that. Not me, not anybody else. You did that. And you can't unmake it public. It's already out there. Even if I never released this video, it's already out there on Court Listener and so forth. Yeah. Okay, so I guess that's a thing on my to-do list. Let's wrap this video up so I can put some more work into that. Thank you for watching. I hope you found this to be interesting or educational. I also want to thank my Patreon supporters at the $50 level: Bottle Shock and Oz, Canada's National Firearms Association, the Canadian Shooting Sports Association, the Canadian Coalition for Firearms Rights, PJs Forever, Angela Skelton, Cielo, Purple Dragonair, and Shady. And at the $20 level, Mark, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunkle of the Baileys, Cameron Johnson, Andrew Elsich, and Marvin CZ. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.